Welcome to this first of what we hope might become a semi-regular series of AYBIL highlights webinars in which we'll be showcasing recent work published in the Australian Yearbook of International Law, or AYBIL. And we're really pleased to have you all join us for this first of this series of webinars. I'd like to start the webinar by acknowledging and celebrating the First Nations peoples from across the world, and in particular, the Ngunnawal people, who are the traditional owners of the land on which the ANU campus resides. And we pay our respects to their elders, past, present, and emerging. My name is Esmé Shirlow, and I'm an associate professor at the ANU's College of Law, and I'm also the AYBIL General Editor. And the AYBIL, for those who aren't yet familiar with it, uniquely aims to combine scholarly commentary with contributions from Australian government officials. And consistent with this mission, today's webinar will feature expert academic and government perspectives on the legal implications of the downing of MH17 in 2014. And we're joined by three really terrific and expert speakers on this issue, including Associate Professor Amy Maguire from the School of Law and Justice at the University of Newcastle. Amy's also the Yearbook's Book Reviews Editor, and she'll be speaking today as the author of an article published in the forthcoming volume 40 of the Yearbook titled Delivering International Criminal Justice Through Domestic Law, the Case of Flight MH17. We're also joined by Jesse Clarke, who is the Acting First Assistant Secretary of the Attorney General's Department's International Law and Human Rights Division. He's also an agent in Australia's proceedings at the International Civil Aviation Organisation against Russia for the downing of MH17. And he's also a Yearbook Editorial board member. So welcome, Jesse. We're also really pleased to have with us Samuel Lucas, who is Counsellor, Legal and Alternate Representative of Australia to the International Civil Aviation Organisation. He's joining us from Canada, where he undertakes the Australian government's engagement on Australia and the Netherlands joint legal case at ICAO against Russia for the downing of MH17. So we're going to spend the next 45 or so minutes discussing our panellists' work in relation to the international law implications of the downing of MH17 before we open the floor for questions from the audience. We've structured it as an in-conversation panel between myself and the three expert panellists. As attendees to the webinar, you'll have your video and microphones automatically turned off, which helps us to keep sound quality clear and reduce interference on the call. If you would like to ask a question, feel free to use the Q&A or chat function at the bottom of your screen at any point during the event, and we'll bank those questions up and save them for the Q&A at the end. Please also note that this webinar is being recorded, and if you don't wish your question to be recorded, you can submit it via the Q&A function anonymously or message the host who will convey it to me to pose to the panellists. So without further ado, we'll begin our discussion of the legal implications of the downing of MH17. And I'll start with a question to you, Sam. Both AGD and DFAT contribute regular features to the yearbook, providing snapshots of Australia's engagements over the year with international law. And in the forthcoming volume 40 of the yearbook, the section on Australia's state practice in international law notes that Australia has, and I quote, remained steadfast in its commitment to pursuing truth, justice and accountability in relation to the downing of MH17. Now, I hoped you could kick us off by explaining what efforts the Australian government has taken to date to achieve these goals since 2014.
And thank you very much for the opportunity to be part of this. And I'd like to begin by acknowledging that the land from which I'm speaking to you here in Montreal is part of the traditional and unceded territory of the Kanien'kehá:ka First Nations. And I'd also like to recognise First Nations' continuing connections to their traditional lands throughout Canada. Many of us here remember our first reactions to the horrific downing of MH17 in 2014. And this really began a range of Australian government activities. The initial consular emergency response focused on access to the site and identification and repatriation of victims. The then Foreign Minister led significant work delivering a Security Council resolution very early on after the downing, which was during Australia's term on the Security Council. And that resolution was instrumental in obtaining access to the crash site, but also made the first demands for accountability just a week after the tragedy. Personnel from the Department of Foreign Affairs and Trade, the Australian Federal Police, the Australian Transport Safety Bureau, and Defence all deployed to Ukraine in support of the effort on the ground. Over time, that emergency response evolved into an investigation phase, together with partners in Ukraine, Malaysia, the Netherlands, and Belgium. We established the Joint Investigation Team, or JIT, and that led to a significant and ongoing effort by the Australian Federal Police working in Ukraine in concert with our JIT partners. The JIT provided that overwhelming evidence base that has underpinned multiple legal tracks to seek those goals of truth, justice, and accountability. This included the Netherlands public prosecutor bringing personal criminal charges against 4 individuals for their role in the downing, and the Australian government provided funding to support the Dutch prosecution and facilitate the participation of Australian families in those trials. A particular focus for us was to internationalise the trials and enable Australian families to observe the proceedings. And we've contributed some $23 million over several years to ensure court proceedings, including the verdicts we saw last week, could be live streamed, simultaneously translated and recorded on a dedicated website. The AFP continues to provide significant investigative support to the Dutch Public Prosecution Services and supports the families of the victims through the Family Investigative Liaison Officer Network. DFAT has administered the MH17 family support package to help the families of Australian victims travel to the Netherlands to participate in the criminal trials, and most recently to attend the delivery of the verdicts last week. And we were very pleased that so many of the Australian next of kin were able to be there in the Netherlands for that process as the Dutch court delivered truth and delivered justice. On the basis of that overwhelming evidence assembled by the JIT, in 2018, Australia and the Netherlands announced that we held Russia responsible for its role in the downing, and we initiated this state responsibility track. We pursued trilateral negotiations with Russia in good faith. The department led 3 rounds of negotiations with Russia in collaboration with our Dutch partners. But Russia unilaterally withdrew from those negotiations in October 2020 and has continually refused to return to the negotiating table despite frequent requests up to and including at leaders level. With Russia refusing to return to the negotiating table, Australia and the Netherlands took the decision to bring dispute settlement proceedings against Russia in ICAO, this being the appropriate forum to consider such a serious breach of the Chicago Convention. This is really just a snapshot of what has been a massive whole of government effort over the last 8 years, drawing together international engagement, legal work, criminal and technical investigations. And it has really been part of the ongoing commitment by multiple governments to deliver that commitment to seek truth, justice, and accountability.
Thanks, Sam. And Amy, turning to you, you focus on one aspect that Sam's just highlighted in your forthcoming article in the yearbook, which is the proceedings in the Dutch courts designed to hold particular individuals criminally responsible for the downing of flight MH17. What precisely have the Dutch courts focused on, and how did these proceedings come about?
Thanks for the question, Esmé, and thank you, Sam. I'd like to start by acknowledging the traditional owners of the land from which I'm joining you from today in Newcastle, the AYBIL and the neighbouring Warramai people, and pay my respects to elders past and present. It's a privilege to be here on this panel to discuss the MH17 case, and particularly timely given that the verdicts were handed down last week. So on the 19th of June 2019, the Chief Public Prosecutor of the Dutch National Prosecution Service issued 4 indictments in relation to the downing. 3 Russian nationals named Igor Girkin, Sergei Dubinsky and Oleg Pulatov, and 1 Ukrainian national, Leonid Karchenko, were charged with criminal offences under Dutch law. And whilst the prosecution conceded, and I quote, that we do not think that these defendants pressed the button that launched the missile, they alleged that they played a significant coordinating role in the transportation and positioning of the missile launcher and in its removal back to Russia, making them so closely involved that they could be held responsible under criminal law for the downing of flight MH17. So the trial was conducted under Dutch domestic criminal law before 3 judges of the District Court of The Hague. And the accused were charged with 2 primary offences, namely the downing of an aircraft and murder. The prosecution based jurisdiction to prosecute in part on the extraterritorial application of Dutch criminal law because the atrocity was a serious crime involving Dutch victims. There was another more concrete source of Dutch jurisdiction to prosecute the murders of non-Dutch victims. That came in the form of an agreement expressed in a treaty between the Netherlands and Ukraine to transfer prosecutorial jurisdiction. So that treaty effectively treated the crime as if it had been committed in the Netherlands, extending its application to all the murders, including the murders of non-Dutch nationals. And the consent of the alleged perpetrator's home state was not required for a valid transfer of prosecution under a governing treaty, which is the European Transfers Convention. So in general, the prosecution of international crimes as domestic offences has attracted some criticism as not sufficiently proportionate to the scope, scale and gravity of the conduct involved. But the approach that was taken by the Dutch authorities in relation to MH17 was clearly a strategic one. And they put emphasis on the fact that, and again, I'm quoting, the offences in the indictment are as applicable to the downing of a military aircraft as to the downing of a civilian aircraft. In principle, any error concerning the target makes no difference in respect of the proof that such offences were committed. So that is to say, the crimes of murder and the downing of an aircraft, as are prohibited in the Dutch Criminal Code, can be established irrespective of the military or civilian status of the victims and whether the accused knew of their status. Had the prosecution charged the 4 accused with violations of the laws of war, it would have borne a significantly more stringent burden of proving that the accused were aware of the protected status of MH17 as a civilian aircraft and that the victims on board were civilians. There were several justifications for mounting the prosecution in a Dutch court. The largest number of victims were Dutch nationals. The Netherlands helped to lead the safety investigation. The Netherlands has a functioning, independent, capable judiciary that would attract international confidence. Also, Dutch criminal trials have an inquisitorial style, particularly in the pre-trial proceedings, meaning that judges can test the veracity of evidence, and that was arguably seen as a protective factor for the unrepresented accused. Also, the Dutch legal system is monist in nature, meaning that international human rights and criminal law norms were automatically relevant to the proceedings, which was hoped to assist the court to deliver justice that would measure up to the expectations of the European and international communities. And just to conclude on this question, Esmé, that being said, it did surprise some that the charges were laid under the Dutch Criminal Code only, without also including some reference to international humanitarian law. The prosecutions did have the option to lay parallel war crimes charges, but chose not to, saying that the suspects were not fighting as part of an international war between Russia and Ukraine. But the choice to put aside parallel prosecution for war crimes was argued by some, as a failure, I suppose, to represent the interests of the international community as a whole in dealing with this atrocity. Thank you.
Thanks, Amy. And just to kind of return to one of the other proceedings that Sam mentioned earlier, Jessie, you're the agent for Australia in one of those key efforts, which is the joint legal case brought by Australia and the Netherlands against Russia at the International Civil Aviation Organization. How did those proceedings come about and what is their focus?
Thanks very much, Esmé. Just hoping after my technical delays you can hear me okay. But I did want to say thank you very much for the invitation to participate today. Obviously a particular pleasure as a member of AYBIL's Board of Editors. And congratulations to Amy and her co-authors for the forthcoming paper. It's excellent. So this is a really timely discussion. Let me just say that I'm joining you from Ngunnawal country today in Canberra, and let me join in your acknowledgement of country, Esmé. Look, Sam has, it's always a pleasure to work with Sam because he does most of my work for me, and he has already laid out the background to this dispute. And really where the ICAO proceedings fit is in that continuation of those efforts for truth, justice and accountability. So as Sam's mentioned, we did invoke Russia's state responsibility together with the Netherlands, and we tried to settle this matter by negotiations, and regrettably, Russia unilaterally withdrew from those. So really that both governments faced a choice of what to do next. We did have several high-level representations made by the Foreign Minister and ultimately by the Prime Minister to urge Russia to return to those negotiations. But when that failed, we needed to think what was the next step. And for us, there are a range of considerations there, but obviously central to that is a key provision in the Chicago Convention. That provision is known as Article 3 bis. And what that requires is that states parties refrain from the use of weapons against civil aircraft in flight. So we were obviously well aware of that provision, and so we needed to think about, well, how do we hold Russia and those accountable to account for that obligation Russia has accepted and is a party to the amendment that brings Article 3 bis into force. So we talked with our Dutch colleagues. We'd obviously done a lot of work and thinking about shaping our case, and really it's a very simple one. We do say that Russia's actions render it responsible for a breach of that provision of Article 3 bis. And I think we'll probably get on to evidence, and I can touch on that in a minute. But it's a very simple case. Now, we say the jurisdiction of ICAO is very clear because in Article 84 of the Chicago Convention, it gives the ICAO Council the obligation to settle disputes between states parties where the interpretation or application of the convention is at question. So we say this is a classic case falling within that jurisdiction. We allege, and have for a long time, that Russia has breached Article 3 bis. We tried to settle that by negotiations and met the preconditions for bringing the dispute under the Chicago Convention. So together, both governments launched those proceedings in March of this year. So I might stop there and we can return to some of those issues as we proceed. Thanks, Esmé.
Thanks, Jessie. I mean, to return to this issue of evidence and I guess a common thread running through some of these legal processes is the aim of establishing truth and establishing key facts around who or what caused the downing of flight MH17. Amy, in your article, you and your co-authors exploring in some detail the contributions Australia made in the immediate aftermath of the downing through the Joint Investigation Team, or JIT. What contributions do you think the JIT made to Australia's goal of securing truth in relation to the MH17 downing?
Thanks, Esmé. And you and Jessie have helpfully reminded me to do something I meant to do at the outset, which is to thank my wonderful co-authors on the paper, Alexandra Garnham, Amy Elton and Jessica Heaney. This has been a very lengthy project actually, and following all the different methods to then narrow down and focus on the prosecution in the Dutch courts. So the JIT was established to carry out the full, thorough and independent international investigation that had been called for by the UN Security Council resolution that Sam mentioned earlier. And the JIT investigators, we've heard already, included representatives from the Netherlands, Australia, Belgium, Malaysia and Ukraine. They set this mission of seeking justice and securing criminal accountability for the victims with evidence that could be substantiated at trial. But of course, the investigation was highly complex and protracted. The search for justice was hampered from the outset. So, for example, immediately following the crash, there were 6 wreckage sites situated in active war zones, and security prevailed over the demands of an urgent investigation in many ways. Days after the crash, news reports began to emerge saying that tragically the victims and their personal effects were being tampered with at the crash site. Then Foreign Minister Julie Bishop labelled the contamination of the site and the removal of evidence as an utter outrage. The lack of immediate and unimpeded access to the crime scene, of course, affected the evidence gathered, and this was something that Defence Counsel raised in their opening statement on behalf of the one represented litigant in the Dutch trial. But the Dutch prosecution maintained that the evidence, despite those early issues, was still collected to the standards expected of the Dutch criminal system. So once investigators did gain access to the site in the summer of 2015, more than 500,000 photographs and videos were taken and examined. The JIT investigators questioned over 200 witnesses. They intercepted and analysed 3,500 conversations. They studied 20 weapons systems and 5 billion internet pages. Ground samples were taken in various international locations and launch sites were simulated in the JIT countries. The investigators also sent 60 requests for legal assistance to more than 20 countries. They examined thousands of parts of wreckage and entered all of this information into a database and reassembled as best they could the aircraft. As many as 200 investigators and other experts were involved in this process, with at least 100 people working on the case daily. And in September of 2016, the JIT announced that it had found irrefutable evidence that the missile that had hit the plane was a Buk missile from the 9M38 series, launched by a Buk Telar launcher that had been brought to farmland in the vicinity of Pervomaisky, which was an area of Ukraine controlled at the time by pro-Russian separatists. And the JIT determined that this missile was transported to Pervomaisky from the Russian Federation and that the launcher was then returned to Russia after the attack. And later in May of 2018, the JIT confirmed that it had met the legal standard for convincing evidence that the missile system came from Russia's 53rd Anti-Aircraft Missile Brigade, which is based in the West Russian city of Kursk. The distinctive markings and serial numbers of the missile were very important in tracing the exact system that was used in the attack. Photo and video evidence that had been shared on social media captured the missile launcher on its journey to and from Russia, and that evidence was supplemented by tapped phone conversations between alleged conspirators. So the defence challenged the findings of the JIT investigation, as I mentioned, and argued that alternative theories, for example, a mid-air plane crash, should also have been considered. And the Russian President, Vladimir Putin, said that the establishment of a tribunal was premature and counterproductive, and Russian representatives claimed that the JIT was pursuing a political agenda. But in their opening statement, the Dutch prosecutors accused Russia of directly obstructing the investigation and alleged that Russian officials and several other people drew attention to evidentiary material that ultimately turned out to be falsified or simply didn't exist. There was a parallel open source investigation conducted by Bellingcat, which supported the prosecutors' claims that Russia was pushing disinformation to shrug off responsibility for the atrocity. So now, with the Dutch court having convicted 3 of the accused, we would conclude that it's fair to say that the JIT made a hugely significant contribution to establishing the truth of what occurred.
Thank you, Amy. Kind of following that thread, Sam, in the International Civil Aviation Organisation proceedings, how do those sorts of proceedings contribute to this goal of establishing truth in relation to the downing? And how does the current situation in Ukraine, Amy mentioned at the time of the JIT, there were fairly active war zones in which some of the evidence was being gathered, but how does the current situation in Ukraine impact on this quest for truth?
Thank you, Esmé, and Amy has done a fantastic job of laying out just how detailed and painstaking and comprehensive the work of the JIT has been. The work of the investigative professionals in there, including our own Australian Federal Police colleagues, has been thorough, it's been dedicated, and it has been comprehensive. And the evidence that they have produced is overwhelming. Their evidence clearly sets out what happened, and it is there and it is evident, notwithstanding the campaign of misinformation that Russia has waged since 2014, which the Australian government has previously condemned. Last week, the Foreign Minister, Penny Wong, noted that the Dutch court had delivered truth and delivered justice. And given the horrific circumstances, the initial mystery of what happened, as many of us can remember from July 2014 in those first few days afterwards, and that active campaign of misinformation, each finding by a respected legal process delivers truth by confirming and cutting through those narratives of misinformation. In the state responsibility case here at ICAO, we are seeking a finding from ICAO, from the Council, from the highest body in international civil aviation, that Russia breached Article 3 bis of the Convention. And a further authoritative finding as to the facts of what happened there will, again, cut through that misinformation. Our case at ICAO is set against the backdrop of Russia's unilateral, illegal and immoral aggression against the people of Ukraine. And the invasion is a gross violation of international law, including the Charter of the United Nations. And it underlines the need to hold Russia to account for its blatant violations of international law, including threats to Ukraine's sovereignty and airspace. But filing this dispute is not part of our response to Russia's invasion of Ukraine. It's about seeking truth, justice, and accountability, as we've talked about, and upholding the rules that underpin and ensure the safety and security of international civil aviation. And there can be no more fundamental provision of international civil aviation law than the fact that you don't shoot down civil aircraft. And that campaign of Russian misinformation adds to the challenge of our case. But as we correct the record, our legal proceedings deliver that truth, and they deliver it for the international community, but most importantly, on behalf of the victims and the loved ones they left behind.
Thanks, Sam. Both of these processes sound like they're creating really important factual findings and contributing to this goal of establishing truth. Jessie, how might these factual findings in these different processes and proceedings interrelate? So could findings relevant to, for example, establishing individual responsibility in the recent Dutch trial have any impact on the ongoing state-to-state proceedings? And or how might Australia's different efforts of establishing state responsibility interact?
Yeah, thanks, Esmé. Look, I'd answer that probably in two ways. First is to sort of pick up where Sam left off, which is to say that, of course, these are all interrelated efforts at accountability. They are efforts to ensure that we know what happened so that these things will never happen again. That's critical to the next of kin if they've made clear in their public statements. So they are very much seen as different avenues to sort of similar outcomes and goals. What I would say, though, is I don't want to over-egg the relationship between the proceedings as a legal matter. And when you talk about transferability of findings, of course, this audience will know that, you know, one international or even domestic finding on a matter of fact will not therefore bind another court or tribunal. And that's to be expected. These proceedings have different obligations at issue. They have different parties. They have different jurisdiction, both subject matter and personal jurisdiction. They can offer different remedies. They have different procedures. So it is not at all unexpected that they will deal with the factual basis quite differently. Having, of course, said that, there is only one version of what happened in 2014, one version of events that's true. So one should not be at all surprised that that common evidence base provides a really important platform for these accountability efforts. And Amy has set out in quite great detail in these comments that the really important evidence that was developed by the JIT and was utilised by the Dutch public prosecution. And it'll come as no surprise, and it would be odd if we did anything different, that we're using the same basis of evidence in the state responsibility proceedings before ICAO, albeit in a slightly different procedural context in relation to a different set of obligations and, of course, different standards of proof, all those sorts of things. So, but, you know, if I just reflect back to the press conference at which the then Foreign Minister and then Attorney General announced the commencement of these proceedings in March, they were very clear to point out the factual underpinnings, and that built on both a technical investigation by the Dutch Safety Board in accordance with the ICAO and the JIT, which we've already heard a lot about. And those key facts, I think, are worth reflecting. You know, that flight MH17 was shot down by a Russian bookteller surface-to-air missile system, that the missile system was transported from Russia to the east of Ukraine, you know, just before the downing, and that area was under control of Russian-backed separatists, that the missile system belonged to the 53rd Brigade, as Amy has already mentioned. From that launch site, the bookteller fired the missile that brought down the plane. That the missile could only have been fired by a trained Russian crew, or at least someone acting under their instruction, direction, or control. And finally, they then took the book back again, back into Russian territory. So you will have heard from Amy and what I've just said, that there is an important common factual basis and evidentiary basis to both claims. And in our view, that is to be expected and unsurprising, and an important basis from which to pursue all avenues of accountability.
Thanks, Jessie. I mean, a lot of these comments have gone to this idea of establishing truth around what happened at the downing, but Australia's efforts, as you've just mentioned, Jessie, also seek to secure accountability and justice in relation to the downing through various parallel efforts in multiple fora. Sam, ICAO isn't a forum many of us are familiar with, and so I wondered if you could just give us some background on how proceedings there work and how they might contribute to that goal of accountability.
Yes, certainly. ICAO, the International Civil Aviation Organization, is the United Nations specialized agency for aviation. It is part of the UN system, but it actually predates the UN. It is created by the Chicago Convention, the Convention on International Civil Aviation, 7 December 1944. And that convention is the basis of modern civil aviation law and of the modern civil aviation system. ICAO's primary role is setting the standards and recommended practices that govern the operation of aviation today. That's everything from the colours on the lights of the wingtips of the plane, to passport standards, to licensing requirements for pilots, but also much less detailed international law, legal frameworks around liability and responsibility and everything that touches international aviation operations. The organisation has a governing council of 36 member states, which are elected for a 3-year term. And the most recent council was elected just in October of this year for the 2022 to 2025 triennium. It's kind of like a UN Security Council, but for aviation. It even looks a little bit like the UN Security Council in its room with lots of blue seats everywhere arranged in a circle. But it doesn't have permanent members. All members are elected every 3 years. The council has, if I can put it this way, legislative, executive, and judicial, in inverted commas, role. That is, it makes new law, it sets standards, it oversees the organisation, like as a board of directors, and then it has this dispute resolution function. And this stems from, as others have mentioned, Article 84 of the Chicago Convention, which is a mandatory provision for the council to decide disputes that are brought to the council by member states that they have not been able to resolve by negotiation. Disputes are not frequent. Until we filed, there'd been, and how many there are depending on how you count them, because a couple of them were 2 cases merged in together, but usually people say there were 8 in ICAO's history until we filed, and 3 of them are in the last 6 years, so they are becoming more frequent. As to how they operate, as to how the cases progress, the council is a political body. It is comprised of aviation experts and professional diplomats from 36 states. It's not comprised of expert judges. And the members of the council technically are the states, not the individuals who sit in the council chamber. So it is the state which takes a position when making a decision. So while the process looks like a legal proceeding with written pleadings and then a hearing and then a decision, it's not a court. And this is why I said judicial in inverted commas. The ICJ has noted that it's not judicial in the very technical legal sense that lawyers would like to talk about it, but it is in that sort of colloquial parlance. It is undertaking a judicial action, and it is deciding a dispute. So persuading those council representatives is as much a matter of diplomatic engagement as it is for being correct on the law in the filings that you put in. And that's why we have a concerted effort here in Montreal, in partnership with our Dutch colleagues, to engage with those council representatives who will end up voting or deciding on our case. We spend a lot of time talking to council representatives, answering questions, explaining our case, summarising the many, many pages of legal arguments, and bringing those council colleagues on the journey to understand the truth of what happened and to see why Russia needs to be held accountable. And this effort in Montreal is mirrored around the world. Australian and Dutch embassies working together to engage all of those 35 other council member states. 35 other, because Australia is on the council, but we don't have a vote on our own case, obviously. Those embassies are working to persuade those member states of that we are correct, to explain the truth and to explain the need for accountability. Our case really does demonstrate that there should be consequences when you breach a really simple and fundamental norm of international aviation law. In previous shoot downs, and it is a sad thing how many civil aircraft have been shot down over the decades, but in other shoot downs, the state responsible has often accepted or acknowledged responsibility in some way. We can see the US's acknowledgement of Iran Air 655 in 1988, Ukraine's acknowledgement of Sibir 1812 in 2001. And in contrast to that, Russia continues to evade and deny responsibility and walked away from its negotiations with us. So a finding by the Governing Council of the UN Agency for Aviation that Russia is responsible under international law will be a significant first, and will send a strong signal that the international aviation community, the international community more broadly, wants to hold states accountable for breaching those fundamental norms, and that we are continuing to uphold the rules-based international order.
Thanks, Sam. Amy, returning to the Dutch courts, what exactly did they decide last week, and how does that contribute to that goal of achieving accountability in relation to the downing?
Thanks, Esmé. Yes, the court handed down a verdict on the 17th of November this year, dismissing all charges against one of the accused, Oleg Pulatov, for lack of evidence. And it's notable that Pulatov was the only one of the 4 accused to send legal representatives to the trial and directly contest his charges. But the court found the other 3 defendants, Karchenko, Gherkin and Dubinsky, guilty on the 2 charges of murder and downing of the aircraft, and imposed sentences of life imprisonment on all 3. The court ordered the arrest of the convicted persons, but with them having been tried in absentia, it appears very unlikely that they will ever be held actually subject to their sentences. But thinking about the extent to which the Dutch trial contributes to accountability beyond that immediate outcome, I was struck by some of the perspectives that were shared by the family members of some of the Australian victims after the verdicts were handed down. And of course, as Jessie mentioned earlier, that there are very many different perspectives among these people, but I thought I'd just mention a couple. Merrin O'Brien lost her 25-year-old son, Jack, in the crash. She described the prosecution as very fair and meticulous. Matthew Horder lost his parents, Susan and Howard, in the atrocity, and after the verdicts were handed down, he said, and I quote, "Overall, it's a positive outcome. It's what we came to hear. The missile downing mum and dad's plane is true. There's some justice. It's not lost on us. The 3 found guilty are unlikely to serve time behind bars, but we've known that since the beginning. They were tried in absentia. Still, something feels different."
Thanks, Amy. Really powerful quotes. Just kind of thinking back to your response and Sam's response, Jessie, how satisfactory are these various options for securing accountability in these types of circumstances? And what might be the attraction or disadvantages be associated with the establishment of other options, for instance, ad hoc or UN mandated tribunals?
Yeah, thanks, Esmé. Obviously, it will be wrong to suggest that this is all terrific and perfect and straightforward. It's not. We all know we have a patchwork of potential and actual options for pursuing these kinds of accountability efforts. And we have to make the best of the system we have. As I mentioned before, there's going to be a range of factors that Australia, and I'm sure many states, would take into account into how to go about pursuing accountability for internationally wrongful acts, or indeed international criminal offences. the jurisdiction, whether they're standing or not, the efficiency, the speed, the rules of evidence and procedure, the resources, the remedies they can offer. So I think states are, with the current system, trying to make a case-by-case assessment as to what avenue or combination of avenues are available and best for in a particular context. And of course, we can see that these options can be pursued in tandem or sequentially, depending on the circumstances. And I think the case of MH17 sort of bears that out. We have to work with the art of the possible. Sam's already mentioned the initial action taken by the UN Security Council back in 2014 when Australia was an elected member of the Council. And of course, that continued into 2015 with the attempt to set up an international criminal tribunal. Now, Russia vetoed that effort, so that door was closed. So I think we need to kind of roll with where we are. It was important to have the international civil aviation architecture swing into force with the Dutch Safety Board inquiry. We thought it was important to join the JIT and support its work. And of course, there are the efforts in ICAO as well. But I should just say, of course, our proceedings are not the only ones seeking accountability in this context. I should mention that Ukraine, of course, has brought proceedings against Russia in the ICJ for a range of wrongful acts in 2014 and beyond. That includes MH17. The Dutch have brought proceedings against Russia in the European Court of Human Rights. Now, of course, Australia is not a party to that convention. We did not join those proceedings. But I think what that just shows is we'll continue to use all available mechanisms, make an assessment as to those that are going to be practically viable, and then those that will serve the particular objectives that we have in a context that like MH17 or any other.
Right, thanks, Jesse. Just keeping an eye on the time, and because we started a few minutes late, we might aim to end a few minutes late as well. We've already got some questions coming in through the Q&A. Before we get to those, I just wanted to give each panelist a minute or two to offer any concluding reflections that they might like to make before we turn to the floor for Q&A. Sam, do you want to kick us off?
Sure. And I think overall, in conclusion, I'd observe that we are on a long road. This is none of these processes are short. None of them are as quick as the families of the victims, as any of us engaged in them would like them to be. We would all like to be able to deliver justice quickly, but it takes a long time. In terms of the ICAO case, we are in a process to address Russia's objection to jurisdiction. We have filed our reply to that, and we are now heading towards a hearing to resolve this question of jurisdiction early in 2023. After that, it will continue, but it will again be a long road. As we head towards that hearing, for the teams involved, it means a long diplomatic engagement effort to get there, to persuade those 35 other council members to back us. And that effort will be here in Montreal. It will be in Canberra with the excellent work that the legal teams in OIL and in DFAT do, and it will be in all of the other capitals around the world where we are engaging. So the quest goes on, but it is a long quest.
Thanks. Jesse, Amy, any concluding reflections?
Amy, did you want to jump in first?
Go ahead, Jesse, first.
Sure. Look, I think my final thought is it's critical that Australia and others continue to support effective international judicial mechanisms, because you never know when you're going to need them. It'd be easy to think, oh, something like this happens. Gosh, wouldn't it be better if the ICJ, was in a fitter state or had a better docket or more parties to its compulsory jurisdiction. We have to work at those things constantly and now, and not wait for when disputes arise. And I think that's important to the Australian government, and we're continuing to do that in a number of ways. Obviously, we need great judges, and it's terrific news that Australia was successful in supporting the candidacy of Hilary Charlesworth to the ICJ, and that the government's announced that it will do so for her re-election next year. We need to show our support for the full range of international dispute resolution mechanisms that are out there. And as many in this audience will know, we've intervened in Ukraine's case against Russia in the ICJ. We've been parties to disputes that arise under UNCLOS, and of course the Timor conciliation, investor-state dispute settlement, something Esmé knows a lot about. All these things, I think it's important that Australia continue to demonstrate its commitment to that process of peaceful resolution of disputes. Of course, because that's the right thing to do, but because we will find ourselves as a user of those mechanisms as well for important national interests and need to be in the best position to advance those interests.
And if I just could briefly add, I think that it remains very important for us to focus on MH17 and highlight the truth of the incident, continue to seek accountability, but also to think about that incident in the context of the ongoing war of aggression that Russia has been waging at various levels in Ukraine since 2014, and to consider the victims of MH17 as forming part of a massive and growing human toll. And so just to highlight some figures, the UN Office of the High Commissioner for Human Rights estimated around 14,500 civilian deaths due to the conflict from April 2014 through to the end of 2021. Sorry, that was total deaths with about 3,400 civilians, and now estimating 6,600 civilian deaths since Russia's invasion of Ukraine in February this year. The chairman of the US Joint Chiefs of Staff has recently given a much greater estimate of 40,000 civilian deaths since the mass invasion in February, and perhaps as many as 100,000 casualties for both Russia and Ukraine this year. And of course, the mass displacement of civilians across and beyond Ukraine has actually driven the global population of displaced people around the world above 100 million for the first time ever. And we have about 8 million Ukrainian refugees recorded across Europe.
Thanks, Amy, and thanks, Sam and Jessie, for your concluding reflections. We've got a few questions in the chat box, so we'll turn to those and probably run over time by about 5 to 10 minutes. So thanks for sticking with us. So Don Rothwell asks, can the panel comment on any ongoing legal issues arising with respect to who may bear responsibility for permitting MH17 to enter Ukrainian airspace in July 2014 and to overfly an active conflict zone? Also, what is the current situation with respect to civil aircraft entering Ukrainian airspace? Don't know which panelist wants to tackle that one.
I'm happy to jump in on the first bit and play for time for Sam if he knows the answer to the second bit. Thanks, Don, for the question. Obviously, we're aware of that issue, but it's quite clear to us that that doesn't affect our case against Russia at all. It doesn't constitute any kind of defence. It doesn't constitute any kind of jurisdictional bar, though, as Sam has already mentioned, Russia continues to create misinformation. It's using its pleadings in the ICAO case to continue that effort. But it very much remains Australia's view that it was Russia, not Ukraine, that introduced the book teller into Ukrainian territory. It was Russia, not any other state, that provided the military crew. It was Russia that moved that missile system out of Ukraine afterwards. So in our view, it's quite clear that responsibility flows from Russia's actions. Sam, I don't know if you've got anything on the second part of that question.
Yes, Jesse, and just to add to what Jesse said there, it's probably also worth referencing that independent experts such as the Flight Safety Foundation have also put out reports which go to this and point to the primary legal responsibility lying there with Russia, as Jesse has outlined, is our case. It's very important to note, actually, that as well as all of this work on accountability for what went on with the tragedy of MH17, a lot of work has also been done in the international aviation system to learn the lessons about conflict zone operations. The recommendations from the Dutch Safety Board went in their usual manner with an Annex 13 investigation through a rulemaking process in ICAO, and this saw new standards adopted in 2020. I can say very happily I was one of the people there who raised my hand to vote to adopt those standards in the council at the time, and those standards boost the requirements for information dissemination and analysis and the integration of that into safety risk management in airlines and in regulators in member states, with the goal of making sure that there is a greater awareness and better management of the risks posed by operations in and over conflict zones. In part because of that, and in part because of some of the lessons that have been learned, the airspace over the conflict zones in the east of Ukraine is now closed to civil aviation. To anyone out there who may be a plane geek, if you haven't got Flight Radar 24 and you're not looking at the aircraft flows, you can see that very clearly by looking at that and seeing the ADS-B data shown in that, which demonstrates that big empty chunk of airspace in Europe over the conflict zone.
Thanks, Jesse and Sam. The next question we have is from Caitlin McKenzie, who's reflecting on the importance of the JIT investigation for establishing an evidence base for some of these accountability actions. And she asks whether Australia, in partnership with the JIT partners, is yet at the stage of sharing and publishing lessons learned through that investigative process to support future investigations in the IHL space, to also have reliable and high quality evidence bases.
Just very briefly, I've typed an answer there to Caitlin with a link to a magazine that's been published by the JIT team. I do think that the effort and expense that's gone into translation across multiple languages and open access to the information involved in the criminal investigation has been fairly unparalleled, and will serve as a great resource if unfortunately it's needed in future cases.
Great, thanks Amy, great to have the link as well. Might have this as the final question from an anonymous attendee who asks, is there an appeal from the decisions of the ICAO Council, and has that appeal mechanism been used in the past? Sam, that one might be for you.
I'm happy to tackle it, but Jesse could also tackle it well as well as Esmé. Decisions by the ICAO Council can be appealed to the International Court of Justice in The Hague. In some past cases, decisions by the Council have been appealed to the ICJ. The ICJ has upheld the Council's jurisdiction every time that has been appealed to it. Most recently, that was in the cases brought by Qatar against Bahrain, Egypt, Saudi Arabia, and the UAE over the closures of airspace as part of the blockade of Qatar that we saw a few years ago.
Thanks.
And just to that, Esmé, the earlier case was between Pakistan and it was an India-Pakistan dispute that was also appealed to the ICJ. And for those students out there, anonymous attendee, you're well informed. It's worth reading that judgment. It makes quite clear what the requirements for ICAO's jurisdiction is and the nature of its functions. And the important thing is that it really only requires two things. One, a dispute in relation to the interpretation or application of the Chicago Convention, and the other, that the attempt to settle it by negotiations has failed. So it's a pretty narrow opportunity to call into question ICAO's jurisdiction here, which we would say is clear in the case of MH17, a point that Sam and I remind others of regularly. But yes, indeed, I think it's a good question to think about as we come to an end. And I'm reminded of Sam's comment that this journey is a long one, and it's not lost on us that there is that appeal function that can follow ICAO Council decisions.
Thanks, Sam. Thanks, Jessie. And thanks to all three of you for your really considered and terrific insights.